Great. Hello, everyone. Welcome to our webinar today, and thank you for joining us. My name is Janice, and I'm the director of the Low Income Taxpayer Clinic here at Maryland Volunteer Lawyer Service. Thanks, everyone. And so I just wanted to go through a few slides about MBLS before we start our topic today. We have a really great speaker, someone who has lots and lots of experience, so lots of wisdom to draw upon, and one of my go-to guys when I have questions about things. So I do want to invite everyone to follow us on social media. You know, we certainly do have various ways of getting information out. We have lots of events and trainings coming up. So if you'll go to our website and look on our events page, you can see any additional upcoming trainings and clinics that are coming up as well. Our office has started to reopen. We've all been working remotely for the past few months, but MBLS is still continuing to do its work and continuing to recruit volunteers as well as place cases. So thank you for joining us. Steve, if you'll move to the next slide, please.
Oh, sure.
Great. So if you are not already on our volunteer panel, we certainly welcome you to join us. It's a great way to take the information that you're learning today, as well as from our other trainings, and apply it to real life experiences. So to find a client, you could go to our pro bono portal that's on our website, and that's circled there. Steve, if you'll go to the next slide, please. Great. Oops. And we, as a member of as a volunteer and a member of our volunteer panel, you are welcome to access many of our recorded trainings, not only in tax, but also in any of these additional topics that we work on. So next slide, please.
Alrighty.
Great. So if you are not a volunteer, we do encourage you to sign up today. And you would do that if you're an attorney, you would apply to be a volunteer lawyer. If you are not, and we certainly welcome CPAs and enrolled agents to join us, you would go to ways to get involved, and there's a link there for how to be a tax representative. Next slide, please. Great. And with that, I'm going to turn it over very shortly. I just want to remind everyone logistically, if you're welcome to ask any questions throughout the broadcast. We do ask that you write them into the questions section. We likely will hold them till the end just so that we don't disrupt the flow of the conversation here. But please do feel free to write in any questions that you might have. So thank you for joining us, everyone, and I'm going to let Steve take it away. Thanks, Steve.
Thanks, Janice. Hi, everyone. My name is Steve Kauffman. As you can see from this screen, I'm an attorney, CPA. My office is in Columbia, about 1,000 feet from where they're building the new circuit courthouse. I have all of my contact information there. A little bit about me. I was an accounting major at Loyola, what was then Loyola College, and graduated in 1977. I became a CPA. I was working at the IRS as a revenue agent while attending Maryland Law School in the evenings. After I finished law school and became an attorney, I went to work for a law firm, then started my own firm. And I've been doing this stuff. Tax controversy is probably about 1/3 to 40% of my practice for about 30 years. So anything comes up, you know, in the future, if you ever have a question about a tax controversy matter, feel free to reach out to me, and I'll be happy to chat with you. Now, I suppose I should have mentioned the presentation is titled An Almost Orderly Presentation. It's because, you know, when you think of IRS audits, you try to figure out where to start. There's a lot of different places you can start, but I've listed here some relevant legal authority. Okay, so we've got 7601, 02, 05, Section 6001. We've got some regulations and a reference to the IRM, which is the Internal Revenue Manual, and we'll probably talk about a lot of these things as we move along. And what I recommend is we'll be covering some of these things, but it certainly wouldn't hurt to do a little independent reading on your own if you're looking to do IRS audit work. So we'll start with IRC, Internal Revenue Code, section 7601. And it states the secretary shall, to the extent he deems it practicable, cause officers or employees of the Treasury Department to proceed from time to time through each internal revenue district and inquire after and concerning all persons therein who may be liable to pay any internal revenue tax, and all persons owning or having the care and management of any objects with respect to which any tax is imposed. And I always like to start with this section, and it's IRC 7601, duty to canvass. And I remember back when I started with the IRS, I was a young fellow then. I was like 21 years old. We did some pretty heavy duty training, and we came to this section and it's like, duty to canvass. What do you mean canvass, right? So, no, it's not this kind of a canvass, right? This is a canvass that's a noun, and this is not the kind of canvass that the code is talking about. So this may be a little closer. Here's somebody out canvassing for votes, for support, in this case for Brexit, but still not exactly. Holmes Elementary, right? And while we don't use the term canvass in connection with Detective Holmes, it's really, this is more what this is about. It's about trying to find folks who have not complied with the tax laws. Let me share with you 2 examples. I call this examples of canvassing from the trenches. So back when I started with the service, we had the district director come in, and he was giving an introduction to the new revenue agents. And I call this one, like a good neighbor, IRS is there and everywhere, and a little frown face at the end. And the district director, whose name I can't even recall at this time, told us a little story. He was an agent. He was moving up the career ladder at the IRS, and he wound up in a new location, was living in a small town, and he and his family shopped at a local grocery store. Well, it just so happens that that grocery store was under examination by an agent that the district director, who was a group manager back then, was supervising. And so he looked in on the progress. He spoke with this agent to determine the progress of the audit, and he noticed that that there were only 5 days a week for the minimum income probes. And when he asked the agent about this, the agent said, well, they're only open 5 days a week. And this district director said, no, they're open 6 days a week. So here's an example of canvassing. And apparently they turned it into a big case, and there was lots of tax dollars just based on, this IRS employee out trolling around. The second little episode in my career, we've all heard the expression, even bad press is good press. And my corollary to that is, unless it's not. So I had what's known as a follow-up audit. In other words, when there's an IRS criminal investigation that results in a prosecution and the conviction, then they've got the IRS has to settle the civil case, and they turn that over to a revenue agent. And I can't tell you the occupation of the individual involved here, because I checked into it, and they're still around, and if I did say what it was, it would give it away. But what I will tell you is when I went through the file and I got to what started it, there was a newspaper article, and that's the press. And this might be considered good press because this individual was bragging about how successful he was. And then the next document in the file, and by this time the file was about 1.5 feet thick, the next document was someone had pulled some transcripts. And the transcripts showed that this individual really was reporting income of next to nothing. So as you can see, that turned into a criminal case. And those are just examples of canvassing and how canvassing sometimes comes into play with selection of returns. We're going to talk a little more about how most returns are selected for audit, but it's possible for them to be selected in unusual sorts of ways. Now, in the next slide, identify the general types of audits. You can have correspondence audits. Typically, that's going to be a situation where there's a math error or some sort of omitted income or something like that, automated unreporter, and there'll be correspondence, and it's pretty informal, and your client gets a notice, and unless they disagree, the change will be made and everybody gets on with life. In contrast, an office audit is typically going to be directed at individual taxpayers, non-business. The agent, actually they call them office auditors, will have 1 or 2 items on the return, itemized deduction, child care credit, that sort of thing, earned income credit. They'll focus on those items. The taxpayer comes into the office, produces produces substantiation, etc., and generally gets it involved there. And then finally, the field office is individuals that have higher incomes. More typically, they're business returns, and they're going to be handled by field revenue agents or examiners, and that's what we're going to be kind of focused on in this presentation today. Now, in terms of employees, and you should always know, when you're dealing with an employee, who you're dealing with. One type of employee is a service center employee. And, you'll probably be talking with a service center employee on the telephone. And, you should find out, get their name. They'll typically give you their last name and an employee ID number, and make notes, date, etc. of the conversation. And if you do get some sort of fax number or something, it's terrific, so that you can follow up a little bit, but you don't have much there beyond that interaction. An office auditor, as we discussed, that's going to be for a small office audit type return. Revenue agent. A revenue agent is going to do a field audit. Now, a SEP agent is a special enforcement program agent. And SEP agents get involved when there are suspicions that there might be fraud. And I've had, certainly over the years, I've had a number of examinations conducted by SEP agents, and it's certainly, a good thing to know that. And they've told me that they were SEP agents, and certainly great care needs to be exercised when you are dealing with a SEP agent, because the case can wind up becoming a criminal tax case. And I will also say this, one of the more important duties, I would think, of anyone who's representing a client in a tax audit is to prevent the case from becoming a criminal tax case. That's going to be key. A revenue officer is not really an examination division employee. A revenue officer is an employee of the collection division, and they don't do audits. They try to collect delinquent accounts. They call them TDAs, taxpayer delinquent accounts, and probably most of you, even for myself, most of the cases I deal with in the tax controversy area, I'm dealing with revenue officers. And then finally, a special agent is an employee of the IRS Criminal Investigation Division. And anytime you have a special agent involved, you really need to have an attorney, because other privileges, and we'll be talking about privileges a couple of slides from now, can wind up being waived in the context of a criminal investigation. And a lot of times, special agents will come out, the taxpayer, doesn't expect them. They come with another person, they flash their badge, they give partial Miranda warnings. They might show up at the taxpayer's place of employment, their office, in the middle of the day, or they might show up at their home maybe a little before, a little after dinner, and they'll want to take a statement, they'll want to interview them, and that's a very dangerous situation. A lot of folks, feel obligated to speak despite the fact that they've been given partial Miranda warnings, and a lot of times after they speak, they've already dug a hole so deep that they can't get themselves out. So beware if a special agent is involved. Now, in terms of authority, what's extremely useful in dealing with an IRS examination, or really almost any IRS matter, is the Internal Revenue Manual, also known as the IRM. And IRM, you can get it online. Just type in Google Internal Revenue Manual and you'll go right there. Probably the two more important parts are Part 4, dealing with examination, and even more important than that most of the time is Part 5, dealing with collection. Now, what this indicates here, and this is taken right out of the IRM, by law, federal agencies are expected to document, publish, and maintain records of policies, authorities, procedures, and organizational operations. The IRM is the IRS official compilation of IRS policies, procedures, and guidelines. So the citation for that is IRM 1.11.6.1.1. Now, what does that mean? IRM 1.11.6.1.1. This slide, we explain that the IRM is organized into parts, chapters, sections, and subsections, and cited in that way. So the previous cite that I just gave you, IRM 1.11.6.1.1, means Part 1, which is Organization, Finance, and Management, Chapter 11, Internal Management Document System, Section 6, Using and Researching the IRM, and subsection 1.1, Background and Authority. So that's kind of how the IRM is structured. Now, when you're dealing with an income tax examination, you're going to want to go to Part 4, which is the examining process. And there's lots and lots of chapters, but probably one of the more useful chapters is chapter 10. And I've highlighted some of the important sections of chapter 10. And section 1, you've got an overview. Section 2, pre-contact. 3, examination techniques. 4, examination of income. 5, required filing checks. 6, penalty considerations. 7, issue resolution. And 8, report writing. So one of the questions that I'm frequently asked is, how does the IRS decide what returns to audit? So in the IRM, and here's the site, 4.1.1.2.2, it's called exam loaded programs. And it reads, exam front-loaded programs are those activities headquarters has determined are of such importance, time must be allocated to them before resources are committed to other activities. The designation of these programs can be found in the annual exam plan. Past year examples include, so the first thing you see there is the National Research Program. And you'll notice that I have NRP versus TCMP. Now the TCMP is the Taxpayer Compliance Measurement Program. And when I was with the IRS, that's what the IRS was using to generate DIF scores. And the DIF score stands for discriminant function. So the way it would work was agents would be given a number of TCMP program returns in different activity codes, different total positive income codes. Returns are classified depending on the amount of income and the type of return. So for example, back in those days, a 113 was a Schedule C with income below $50,000 or something like that. And the 114 was income, a Schedule C with income much higher. And the IRS, based on decades and decades of experience, determined that a lot of adjustments came from those types of returns. And the reason is because, number one, folks operating a Schedule C are probably a little less sophisticated than other folks. They're gonna make mistakes. Small businesses owned by just one person, you could have a lot of personal items going through that could be that are deducted that probably should be reclassified as non-deductible, and possibly even some skimming. So the way it worked, you would be assigned a TCMP return, and you would audit every item on the return to the penny. And you had to meet with the taxpayer. So as you can imagine, it was a very anxious sort of occurrence for a taxpayer, dealing with an IRS audit and face-to-face with an agent. And the service got a lot of complaints about that. So in the 90s, they kind of scrapped the TCMP program and went with this National Research Project, which is similar but different. It doesn't necessarily require the face-to-face meetings, and only certain items are selected, but the agent still is required to go into a great deal of detail. And the intent is, of course, to develop DIF scores, and the higher the DIF score of a return, the greater the audit potential. So if an NRP return is used to score other returns, then let's say we're dealing with 007 type of return, every return in that category that's filed would be given a diff score depending on the extent to which it differs from the program returns. The higher the diff score, then the greater the likelihood that there will be audit adjustments. And as the examination function needs returns to audit, the higher diff score, excuse me, returns are sent down first. That's a big part of the way returns are selected for audit. There's also return preparer projects. There are some return preparers whose returns are adjusted, have mistakes at a much higher rate than what's expected. They can wind up in a preparer project. If they do, then it's possible that all or many of the returns they prepared will be selected for audit, so that's not a good thing. There's an abusive transaction program. Sometimes there are tax shelters, abusive tax shelters, and these abusive transactions are identified, and the returns that claim deductions associated with these abusive transactions are identified and sent out for audit. Offshore has really become very big, the FBARs and other items as well. And I'm starting to see a lot of, and have had a lot of FBAR and related transaction work. Interestingly, I had an audit recently where there was a huge gift. And I came to find out that if a taxpayer receives a gift from a foreign person and the gift is $100,000 or more, there's an obligation to file a form 3520. Lots of people don't know that. And if the 3520 isn't filed, there's a penalty equal to 5% per month up to a maximum of 25%. So in the case I had, the gifts were extremely high, millions and millions of dollars, and there was lots of money at stake. But it was kind of interesting. We settled it on the fact that the agent who was working the case, agents are required to get approval of penalties, written management approval before they propose penalties. And it's the initial determination that they're going to propose a penalty, and there's some case law on it. It wasn't that well defined, and we convinced the tax. This was in tax court. We convinced the tax court in this case that they hadn't gotten the proper management approval, and we wound up settling for pennies on the dollars. It was a very interesting and fun case. Underreported, unreported income, the matching of information reports, 1099s with what's reported on the return. Special enforcement, that's SEP agent and fraud program. And then of course, training. When I was working at the service back in those days, we had, I guess, a month and a half in classroom training, a month and a half where we were working as office auditors with, one day we do medical deductions, and then we do taxes and interest and yada yada, and then a month and a half additional classroom training, and then a month and a half of OJT, on the job training, where you would go out with an experienced agent and do actual audits, and it was great experience. So those are really some of the more important types of returns and how they're selected. For a field audit, from an IRS perspective, they're going to break an audit down into pre-contact, contact, and keep in mind your initial contact by a legitimate revenue agent is going to be by letter. You're going to get a notice of audit. You're going to get an information and document request, an IDR. They're going to want to do an initial taxpayer interview. They're going to want to inspect the business premises. They're going to review documents that have been produced. Issues will be discussed, and then what I call next steps. So this is really from the IRS perspective. And what we'll look at next is how we want to deal with all of this. My apologies. So what I have here is before the initial meeting, preparation is the key, and expect the unexpected. As I mentioned earlier, one of the more important things may be to make sure that you retain whatever privilege is applicable. So there is a federally authorized tax practitioner privilege, IRC 7525, but that's, that only protects so much, and it certainly doesn't apply if there's any criminal conduct involved. So the last thing you want to do as an enrolled agent or as a CPA is to wind up waiving a client's Fifth Amendment privilege, very early on. What I mentioned next, the Cavell type arrangement. Cavell was a case, and it basically provides that if you have an IRS criminal investigation, and if there's an attorney, and the attorney retains, for example, a CPA or an enrolled agent, and the CPA or enrolled agent is doing work to help the attorney to understand all the financial aspects of the case, then the attorney or the CPA will be protected by the attorney-client privilege. So in situations where there may be criminal conduct involved, we call them eggshell audits and other terms, landmine audits, whatever. It's not a bad idea to use a Cavell type arrangement. Now, in terms of the interview aspect of an examination, I think it's really very, very important. Obviously, anyone who's going to be interviewed, your client, if you're going to permit your client to be interviewed, needs to be prepared for the interview. If it's a non-client, for example, if it's an employee of your client's business, great care has to be taken there, because they have to understand that even though you're an attorney, for example, you're not representing them. And there can't be any confusion about that. Additionally, when you're meeting with a client, you have to take care that if someone else is there with them, that can result in the waiver of a privilege. But, preparing for an interview is important. And in order to prepare for an interview, you really need to understand the case. And to understand the case, obviously you'd have to look at the return. You'd have to understand the return. You have to understand the way their books and records are organized and work. You'd have to go through to make sure you understand what the potential issues are, and very importantly, protect yourself. Make sure things are in writing. If you have someone who can, from your office, who can join you for these interviews, do that. Maybe make some file notes afterwards, just so someone can't come back and accuse you in the future of having recommended something improper. Very, very important. To prepare for the audit, it's also important, as mentioned, to look at returns and records. So in addition to looking at the return or returns under examination, you'd want to look at prior and subsequent years to make sure everything is consistent. You'd want to look at related returns. For example, if you've got an S corporation, you'd want to look at the shareholder or shareholders' returns. You'd want to look at large, unusual, or questionable items, LUQs. You'd want to try to reconcile the returns with the books and records. Now, once you get into the audit, it's important to control the audit process to the extent that you can. So when I mention here, you'd certainly want to be, if third-party employees are going to be interviewed, you want to be there. Certainly, if your client's going to be interviewed, you want to be there. If your client has criminal concerns, in other words, if there's substantial amount of unreported income, or your client is a contractor and built their McMansion through their contracting business, that's a problem. So a lot of times, you don't necessarily want to have your client interviewed, and sometimes the agent will agree with that. Sometimes they won't agree with that. If they won't agree, they might issue an administrative summons. And if we have time, we'll talk a little bit about administrative summonses at the end. But the thing that's important to remember is I've got here 18 U.S.C. 2, 18 U.S.C. 1001, and IRC 7206. 18 U.S.C. 2 and IRC 7206 are aiding and abetting. So if you do something that's improper in this context, you can be charged with a very serious crime. And then you'll notice 18 U.S.C. 1001, it's been in the news a lot lately, and that's a false statement, even if it isn't under oath. Any false statement you make to, for example, a federal employee, whether it's an FBI agent or an IRS employee, even if it's not under oath, that's still a crime. And a lot of folks wind up getting prosecuted for violations of 18 U.S.C. section 1001. Inspection of the business premises. When I was an agent, they always encouraged us. In fact, they would insist we inspect the business premises, and it was amazing. I always had, I don't know, I like people. I would talk with folks, and they always told us, and I'd feel terrible about this, but you'd be out there and you'd say, we're going to Yellowstone this summer. Oh, I went to Yellowstone such and such, and you'd make a note of these things, and then you'd look, for example, to see if they were taking deductions during the period of time when they said they were on vacation and what those deductions were. Terrible, terrible, terrible stuff. But agents are out there striking up conversations, listening, making mental notes of everything that's said. And it's almost impossible to prepare for everything because there's a lot of off-the-wall stuff that you don't even know. So, in terms of inspecting the business premises, in terms of interviewing, you keep it relevant, you keep it short, you keep control of the process to the extent you can. IDRs, the information document request, and these cases revolve around IDRs, and the IDRs are numbered and you have response dates. So the first thing you want to do is you want to look at the IDR and make sure that the documents that have been requested are reasonable and relevant, and perhaps even more importantly, that the due date is something you can do. If they send you an IDR and then it asks you to produce a huge volume of documents the next day, obviously you can't do that. So what you do if you have a problem, object in a timely fashion and get that to them. And additionally, make sure that you get everything together, completely responsive to the IDR, determine if there are any potential issues there. And typically you don't have a Fifth Amendment privilege in documents, but there may be another kind of privilege called the tacit authentication privilege, which may come into play. And then you produce these documents for inspection and copying. And typically, we like to keep control of the documents and the copying process, etc. Now, during the audit, you want to keep advised of the status, speak frequently with the agent to find out, where they are and how much more they expect to need. You want to keep apprised of what issues there are. Want to make sure that when they finish, there's going to be a closing conference. You want to make sure that you understand the issues and have time to prepare for it. And then finally, at the end of that process, there's going to be a decision. Maybe the case is a no change case, which is terrific. Maybe there is a proposed change, which would be an agreed case. There would be a form 4549 or 870 signed, and then we'll talk a little bit about refund litigation, because this may not be the end of it. Even if you agree, you may want to agree for strategic purposes. Maybe they've missed something huge and you want to just kind of get rid of the case and then deal with it later. Or there's also the unagreed case, in which case they'd issue a 4549A and an 886, and also a 30-day letter. So the 30-day letter gives you the opportunity to go to the IRS Appeals Division. You would prepare a protest. When you meet with the appeals officer, it's informal. They can consider hazards of litigation, whereas an agent can't consider hazards of litigation, but you can actually reach a settlement with an appeals officer. At the conclusion of an appeal, it could be, again, no change. It could be agreed, in which case you could be asked to sign an 870 or an 870 AD. The difference between an 870 and an 870 AD is if you sign an 870 AD, that's it. No more appeal rights after that. If you sign an 870, you could still, after you pay the full amount of the tax, file a claim for refund and do refund litigation. Or the case could be unagreed, in which case you're going to get a 90-day letter. And the 90-day letter is also known as the statutory notice of deficiency. Now, the difference between deficiency and refund litigation is if you get a 90-day letter, you have the right to go to the tax court without paying the tax first. And that's only going to be in an income tax case. In contrast, if you agree to the tax and you want to do refund litigation, you've got to pay the full amount of the tax, penalty, and interest. There's a Supreme Court case on that, Flora v. US. You've got to file a claim on a Form 843 with the IRS within 2 years after the tax, penalty, and interest have been full paid. And then you'd have to file suit in a US District Court or Claims Court within 2 years after that. In the district court, if you're doing refund litigation, there's a potential for getting a jury trial. In the tax court, which is prepayment deficiency litigation, even though you don't have to pay, there's interest that continues to run on the deficiency until the case is resolved. So you might want to look at posting a bond. Sometimes, taxpayers don't have any choice but to go with tax court litigation because they don't have the ability to pay the full amount of the tax, penalty, and interest, and they don't agree with the proposed adjustments. The tax court is a national court, but the law that the tax court's going to apply sometimes is different from jurisdiction to jurisdiction. That's because of the so-called Golson rule. The Golson rule looks at the appeals court to which a tax court case would be appealed. And even if the tax court doesn't agree with the law, that's the law it's going to apply. For example, if it's sitting in the Fourth Circuit and its position is different than the Fourth Circuit, it will still apply Fourth Circuit law. Again, when you're preparing a tax court petition, it's extremely important to be filed timely within the 90 days, otherwise you're barred. It's also important to understand the issues in your position. The tax court case, it's typically a cooperative process. The goal is to stipulate to as many facts as possible. A lot of tax court cases are disposed of via motion. A lot of cases are settled. If they're settled, there's a stipulated decision. If there's a trial, the issue is whether it's trial de novo and most income tax cases will be de novo or on the record. And for example, for CDPs, there are some times where it's going to be on the record and the record rule applies. After a tax court case, you could, if you're unhappy, you could appeal to the Circuit Court of Appeals, and beyond that, you could appeal, if you have enough money, to the Supreme Court, assuming they grant cert. That would be about the end of it. As opposed to the deficiency litigation, if you're doing refund litigation, you would file your claim, you would file suit again in district court or claims court. After that, the appeal would be the same to the Court of Appeals and to the Supreme Court. I have some other special topics that I was going to mention if we had time, but it looks to me like we're getting a little bit pressed. It's 12:48, but perhaps we could cover some of these other topics in some future session. Does anyone have any questions?
Yes, if anyone has any questions, this would be a good time to go ahead and put those in the question box. I don't have any at the moment, Steve, but I have one question in terms of the agreement about signing the letter after an audit. You know, because we often, it's not uncommon for clients to walk in our door after an audit and say they had no clue that they were even audited. So, and do you think that's more commonly that perhaps they just didn't get the 90-day letter because they didn't sign anything, then they got the 90-day letter and then just either ignored that or didn't receive it or something? Or
yeah, I think that's typically what happens. I find that a lot of clients tend to bury their heads in the sand when there's unpleasantness about it.
Mm-hmm.
Let's face it, you know, when you're getting correspondence from the IRS, it's typically not good news. So
Right.
a lot of folks tend to ignore these things, and the next thing you know, they're getting these notices, and you know they've already defaulted, and the tax has been assessed.
So, okay. And then, what if they call and then they set up an installment agreement because they don't understand what's going on? Is that sort of implicit agreement then?
Well, I mean, you've got the different types of installment depending on the amount of tax. You know, you can have the guaranteed versus the streamlined for the different cutoffs. I believe it's 25 and 50,000. And then over that, it can be a larger amount. And if they've entered into an installment agreement that really doesn't work for them, you'd have to try to renegotiate that. And of course, if they default, as you know, the IRS will terminate the installment agreement. And sometimes in that termination process, you can renegotiate a new installment agreement.
Mm-hmm. And then where does audit reconsideration come in to this?
Well, audit reconsideration, there's a provision in the IRM dealing with that, and if there's been an audit, then there's new facts that come to light that lead you to conclude that for some reason it's inequitable and unfair, and you can request an audit reconsideration. And sometimes it works, and I certainly well, like a 60/20B for a substitute for a return, a lot of times what happens there is if you just filed a return, the IRS will accept that filed return. Sometimes not, but so anyway, that's the way that works.
Okay. So now I do have a question regarding an extension.
Right.
So
A Form 872 extension?
I think so. So it says, is it advisable to sign an extension when there is less than 1 year left on the collection time, and the IRS will not send the matter to appeals because there is less than 1 year? So it goes to tax court. Is it advisable for the client to sign a CSED extension?
The CSED extension. Well, I mean, I'm not sure how frequently the IRS asks for CSED extensions anymore. I mean, most of the extension requests that I get in an audit context are 872, an extension to extend the time for assessment. And typically, in an audit, that does make sense. In terms of a CSED extension, if they're still doing that, and I haven't seen that for a while, I think it would depend on the facts and circumstances. Now, of course, if you file a CDP request, right, that's going to toll limitations on the collection statute. And what you may want to do is certainly look at the CSED before you take some action that's going to toll it, and then look at the client's financial condition and give some thought to whether you want to do that or just not do anything. And a lot of times you're better off not doing anything in a collection situation.
Okay. Great. So I think the question was in reference to the 7482 extension.
All right. I think it really depends on the facts and circumstances.
Sure.
Yeah.
Okay. Great. There's this one other question I want to answer quickly, but then after that, I think that Steve, we have a few minutes. Maybe you could just briefly go over these special topics in terms of maybe a quick description of what they are.
Sure. Yeah.
But this is sort of a more general question, and the question is whether the IRS is working cases now, and how do we contact them? Are they closed because of COVID? My understanding is that a majority of the offices are closed right now. They're starting to open some of them up. I heard recently that the Ogden CAF unit has started opening up and is now accepting faxes. But I think that my sense is that things are still moving very slowly to open. I don't know what your experience has been, Steve, but
believe it or not, I've got a couple of I have 2 audits that just started, and they're pushing things aggressively. And you remember there was that notice that was issued that gave delayed everything until July 15th. Well, they sent me an IER and they were asking for all these documents, and I asked for an extension until July 15th that we should have been entitled to anyway, and they granted it. But yeah, they're still working, but I do find that it's response times are not all that great, and particularly if you're trying to do something with some function other than an examiner or a revenue officer that you're dealing with.
Okay. This is a very interesting time that we're in right now. So,
yes, indeed.
So yeah, so Steve, maybe with the remaining few minutes, if you could just sort of quickly go over what these terms are, it'd be helpful. Like, what's an eggshell audit? That's very curious to me.
You know, I mentioned eggshell audits before. That's the classic situation is you're representing a contractor, and the contractor built a huge home, personal home, through their business, and they're writing off labor, they're writing off materials, and so that's a problem because it's a materially false return signed under penalties of perjury. It's a violation of 7201. It's criminal. It's evasion. It's criminal conduct. And let's say that return is selected for an audit. That's an eggshell audit. And there's a lot of things that a lot of decisions that have to be made very quickly. They better be the right decisions on an eggshell audit. Eggshell audits are very tricky. IRS summonses. When documents are requested, sometimes or the service asks for an interview and someone refuses to be interviewed, they will issue an administrative summons. Sometimes the folks won't comply with the summons. So the IRS can bring an enforcement action, and that's where the PAL standards come into play. And under the PAL standards, the IRS has a minimal burden, but it has to show that the requested information or documents are relevant to a legitimate purpose. They don't have the information or material in their possession, and they've complied with all procedural requirements. That's what they have to prove. In my younger days, I litigated a couple of summons enforcement actions. It can be expensive. Sometimes you can get a summons limited. Sometimes you can get some discovery, but a lot of times the juice is not worth the squeeze. The ASED rules are, the assessment statute expiration date. And of course, the general statute of limitations for assessment is 3 years. There's a 6-year statute for substantial understatement of income or overstatement of deductions. That's 25%. There's no statute for assessment if there's fraud. If there's fraud, there's no statute, or if a return isn't filed, no statute of limitations on assessment. And the penalties, we talked about it a little bit, but it's certainly the penalties that you see all the time are the delinquent filing, which is 5% per month up to a maximum of 25%. Delinquent payment, which is 0.5% per month, going to 1% per month, up to 25%. The combined is 47.5%. And then, other penalties come into play as well. Substantial understatement, negligence, all those sorts of things. FOIA request. I use FOIA requests from time to time just to find out what the service has in its file. And then offshore, we talked about offshore a little bit. That's just kind of to give everybody an overview of, some of the special topics that kind of relate to audits.
Great. Very good. Well, I think that kind of wraps us up. Perfect.
One thing, I'll just put this last slide up. Again, anybody with any questions, feel free to contact me. I'm going to be starting a tax blog soon, like everybody in the world, but that's my contact information.
Great. Wonderful. Well, thank you everyone for joining us. And again, I sent out a chat earlier, but for anyone who is interested, Steve has graciously agreed to allow us to post this, post the webinar and the slides on and make it available to our volunteers. So thank you, Steve, and thanks everyone for joining us. Take care, everyone. Stay safe.
Bye now.
Bye-bye.